All right, everybody, welcome in. Welcome back into Let's Talk Live here on the LTL Media channel. Tonight is Friday Night Heat, and we had some heat inside that courtroom in the Karen Reed retrial. Today, we're closing arguments. Each attorney, Alan Jackson and Hank Brennan, had about an hour and 15 minutes to close out the Karen Reed retrial. And all I have to say is Alan Jackson, masterful, passionate, convincing. Hank Brennan lacked enthusiasm, lacked direction, and lacked conviction. It was, and then we had the long, sleepy instructions from Aunt Bev. And then we had this handed over to a jury. About 2 hours of deliberation today. And then, well, it was close to 5 o'clock. We had to get everybody out of there because it's Friday. Cottage time. We'll see on Monday. But I want to bring in some amazing guests this evening to the stage. We have one here, retired Mass State Police Todd McGhee. How are you?
I'm good, sir. How are you?
Fantastic. And the one and only Nan. How are you?
I'm great, Brian. Hi, Todd. How are you guys?
Hey, Nan.
I'm well. So let's kick this off. Todd, first impressions today of Alan Jackson and Hank Brennan.
Well, I concur with your thoughts, Brian, but here we are, right? Finally awaiting this stage of the trial. The witnesses have testified, the attorneys have presented their strategies, and now the jury has the verdict slips, and they are now deliberating. So a long-awaited time to get here. This time seemed like it went a lot faster, but here we are.
Nan, what'd you think about Jim showing the ping pong balls, and then also first impressions about Alan Jackson and Hank Brennan today?
So everyone has to give me a little grace tonight because I didn't watch every piece of it because I was streaming on a different channel. But I thought I heard that the judge did not allow there to be transparency in the bingo ball process. Did he show the bingo balls? Is this news to me?
Kind of took them out and put them down.
You put them, but he didn't show the numbers to anybody.
No, he's just taking them out and going,
This is so ridiculous. The request for transparency, I'm kind of sitting back because I'm tired tonight. But if you guys can't hear me, let me know.
You sound great.
Thank you. The lack of transparency is so egregious to me. I mean, the fact that the attorneys had to ask for transparency just leaves me saying, what is going on here? And the fact that the judge denied the request, this is unheard of, especially when this judge has allowed transparency with respect to alternate juror selection previously. Thank you, Pluto is a planet. How did I read that without my look guys?
Listen, I'm going to tell you right now, guys and ladies in the audience, I don't have my glasses. So it's going to be really hard for me to read chats, but I'm going to try to get through the best I can tonight. Nan, I'm sorry for cutting you off.
No, that's okay. I got my blue bad boys on for tonight, so I got you. But so the fact that look, I can't speak to which jurors were booted. I can simply tell you that I'm sure there's something nefarious at play. So we'll see. But as far as my overall takes in terms of AJ and Brennan, AJ gets an A+, Brennan gets an F-. And I'm happy to dig deeper. If anyone wants like the real details, I'm sure we're going to get into it tonight. But Brennan, absolutely an abysmal performance. And I have to say, way to steal the free Karen Reed.
I'm so glad you said that. I know where you're going.
Come on, like look the other way. Couldn't you come up with something a little bit more original? I guess it does work for both sides, but we had it first. So, go get your own ball and go home.
Let's get the ping pong balls and we can show them, show the numbers on the ping pong balls. I mean, come on, Todd. No transparent. Yeah. We get the bingo ball process. Jim takes them out and is just he's looking at the number like this and just placing them on the desk. Come on.
Did we think we were going to get anything better?
I guess, if you don't set high expectations, otherwise you'll be disappointed. So, I think we all expected this to happen, and it doesn't happen elsewhere. Like on my planet and every other planet in the universe, this doesn't happen. So let's hope that the jurors that are the 12 are independent thinkers who have reason to be skeptical of law enforcement, who can put biases aside, who can simply draw upon not even the closing arguments, but the ultimate duty that has been entrusted upon them, and to do the right thing. It's not to look the other way, it's do the right thing.
Yeah.
It's the most clearest case of reasonable doubt that I have ever seen, and I'm dating myself, but in a quarter of a century of practice.
You know what I found very funny? When Hank Brennan talked about Barros, he said that I found it funny. I made this note. Let me just find this so I quote my note correctly. I'm sorry for like dragging down the show here, and I should have had this up earlier. But let me just pull my note, because I want to make sure I read this correctly. So I put a statement out there about Barros, and I said, it's funny how Brennan dismisses the conspiracy with the officers and everyone that was involved at 34 Fairview the night that John O'Keefe died, yet creates his own regarding the testimony of Officer Barros. Isn't that funny that he did that? Turned it around, said that, it was the defense that had him over for to the hotel, hung out in a conference room with them. And then, his testimony slightly changed, and he's like talking about this to Barros. Todd, what did you pick up on that? What did you think about that?
Well, I liked AJ's response in his that would have been the redirect, I believe, at that point. But he goes, I don't live in Massachusetts. we had our meeting in a conference room at the hotel. Yeah. Sounds kind of standard business practice to me.
Yeah.
Yeah. Can I chime in here, Brian, please? Okay. The fact that Brennan pointed to things like this in the closing, things like he went to their hotel to get a subpoena, and there was another witness, and I can't precisely remember because I didn't take notes. He pointed to another witness who had like an axe to grind. I think it was Russell. Like Dr. Russell inserted herself into this action. That means he's coming from no position of strength. It just means that when you have the facts on your side, you go with your facts. If you have the law on your side, you go with the law. But when you don't have the facts on your side, go with the law, and vice versa. He's sitting here just nitpicking stupid things that are irrelevant. And I'm telling you all, I laid eyes on this jury. I can't guarantee anything, but I read jurors for a living as part of my job, and they aren't going to be receptive to that. Any jury could be receptive to legitimate points on data that refute the defense's position, but Brennan couldn't even point to legitimate data points. He just kept banging his clipboard or binder and saying the data, the data, the data. But if that's the case, the data is showing that John O'Keefe was in the house. And I loved what AJ kept saying, which is, whether he was in the house, in the garage, in the basement. He presented a menu of options that would have made it reasonable for this jury to conclude, and in accordance with the fact that even Commonwealth experts conceded that he was or could have been in the house, most notably Ian Whiffen. So, I'm going to go on and on tonight about how Brennan gets an F-, but it is horrible. And I heard from someone in a chat that the Twitter is saying he did such a great job. I'm like, who is saying that? And what kind of drugs are they taking?
Yeah, and another tactic that Brennan was using was he was trying to make the defense witnesses, feel bad about any conversation, any dialogue, any communication that they might have had with Alan Jackson's team. That's standard protocol. Of course, you're going to have a conversation with the attorney representing the defendant.
Yes.
He's calling you. So
I mean, that's what we do. Like, lawyers prep experts. We prep witnesses. I've prepped witnesses in my own house. I've prepped witnesses at my office. I've prepped them in hotels. I even, no lie, prepped a witness in an electrical closet. Don't ask. That's one day we'll have a whole show on Nan's stories, but that is what I did. And it doesn't mean that, anything stupid or silly or, risque was happening in that closet, but you do what you can with where you've got it. And Karen's team, more than 3/4 of it is from out of state, so they're staying in hotels and there's a conference room. I wouldn't have even cared if Barros went to AJ's hotel room. It's just, these are honorable officers of the court, and there's no evidence other than this kind of side-eye implication that something bad was afoot. And that's just not the case. I don't think the jury's going to buy it, Brian.
Yeah, I think Brennan was, again, because a lot of people that are probably sitting on that jury don't know a lot about the legal process of things that go on in legal process and prepping witnesses and having conversations with them before, they enter trial. That happens. You prepare a witness. You may go over some statements. And I think that Brennan was trying to obviously turn that into something nefarious and evil because they might not know the process. And again, what was the statement? Like, treat the jury like 6-year-olds. You need to educate them at the kind of lowest level and take them through this journey. And I think that the defense did that this time around. I was just like, I watched just such passion and enthusiasm and, like AJ for that hour and 15 minutes and having to, and just, navigated the jury through this journey and used his slides very appropriately.
Yes.
And then you just get to Brennan and it just seems so scattered. It's just scattered. And he's like going here and then he's taking it here and going over here. And it's like, it was like 3rd grade finger painting, like Welcher's.
There's no flow.
It was
like
nothing.
If I'm following along, regardless of who is giving their closing, you still want to be able to logically follow what they're presenting, so you can consume it, so that you can understand it. And the disjointed back and forth to the videos to his closing remarks, it was just scatterbrained all over the place.
And I think there was one video that Brennan meant to bring up, and it actually was like the wrong video or something like that.
I heard that.
On him. It backfired on him. A couple of great quotes from Jackson. And then what we'll do is I want to pull some videos up here in a minute. We'll play like the first 5 minutes of Jackson's open and then the last 5. And then we'll compare that to Brennan, first 5, last 5. But I love some of these quotes. First words out of AJ's mouth. There was no collision. There was no collision. There was no collision. And that's just testimony to the 3 charges that Karen Reed has up against her. I thought that was a nice tie-in at the very, very beginning. 1, 2, 3 charges. No collision, no collision, no collision. Another quote by AJ. This case was corrupt from the start. It was corrupt by biases, conflict, and personal loyalties that you heard about. And most fatally, it was corrupt by the lead investigator whose misconduct infected every single part of this case from the top to the bottom. Now, Todd and I were talking backstage about Proctor, and we felt that AJ could have dug his heels in a little bit more. Todd, if you want to just talk about a little bit what we were talking about before we came on the show.
Yeah, I found it interesting that, I was glad to see that he brought up Proctor in light of no Proctor testimony. That being said, I still thought there was more meat on the bones, where he did mention that Proctor's termination was a result of biasness. That one charge in the discharge papers from the state police, there was more there that I thought he could have educated the jury on in his closing. So again, I'm glad that he brought it up, but I thought there was more he could have worked with.
I have a comment.
Nan, before I go to you, I was going to say, and I also think that they had an opportunity. I think AJ had an opportunity to turn and say, look, and they didn't even want to call the lead investigator. They didn't even want to, the Commonwealth didn't even want to call him. That's how dirty he was. And I think that would have been a great point that Jackson could have got in there as well. I'm sorry, Nan, go ahead.
Oh, no. So as far as the disciplinary order, whatever it's called up there, as to the discharge and termination of Proctor, I have a sneaking suspicion that the judge would not let the other findings in. because the one that was, I believe, specifically attributable to Karen's case is the bias one.
Yeah.
Knowing the way Bev works, she probably would not let the defense get into all the other meat on the bones, which, by the way, Todd, you'd be proud. I use that. Sorry for glitching.
That's okay.
It would not be a stream without Nan's technological failures. But so I have a feeling that Bev kept them on a tight leash with respect to that. And I also, I like that AJ was able to point to Proctor. I thought he did say in his closing that, and they didn't even call him. I thought I heard that.
I think I heard that. Yeah.
Okay, yeah. Then I'm all right. I'm wrong.
Now, do I think he could have hammered it harder? Sure, he could have hammered that harder. But at the same time, again, as someone who's reading the tea leaves here, I have a sneaking suspicion that Bev kept that on a tight leash as well. I'm just happy that they allowed the defense, that she allowed the defense to say, hey, even the Commonwealth didn't call Proctor, because technically that's starting to touch upon that missing witness charge. Because you're supposed that missing witness charge that was requested and then rescinded was designed to permit the defense to draw an adverse inference before the jury by very virtue of the fact that the Commonwealth didn't call him. So the defense was towing a line as to whether or not they could really re-emphasize that greatly. But overall, I thought it was a very, very effective closing argument. And it was, to Todd's point, Brennan's was scattered. And AJ's was very linear. And AJ's told a story. I'm all about telling stories. Yeah. So had I written it, I would have done just what AJ did, and the team, which is put it in a manner that can be remembered and easily understood and digested by a jury.
Yeah. And let's see, Amber E's is agreeing. Says, very good point, Nan. Bev resigned in a lot of what the defense could say. Yeah. Again, I go ahead, Todd.
No, I didn't have anything.
I thought you were going to jump in there. No, yeah, and I do. I think that that they had some opportunities to dig in a little bit more. All right, let's pull up AJ. Let's hear like the first 5 minutes, and then we'll take it up to the last 5 minutes and just get everybody a little bit of taste of what happened today. Obviously, I'm not going to pull the full thing because that would just take forever. We're not going to do that.
It was so good. I'm going to listen to it again and again.
Yeah, we'll do 5 minutes and 5 minutes at the end. Here we go.
There was no collision. There was no collision. There was no collision. I want to take a minute to start off with thanking you. I want to thank you for your attention. I want to thank you for your patience. I want to thank you for your diligence. This is not an easy undertaking. Most of all, I want to thank you for your courage, because courage is what this moment demands. Not just to listen, but to stare directly at injustice and say, not here, not now, not on our watch. That's what you're being asked to do. Stare down injustice. I want to start with a simple truth. You folks, not us, nobody else in the courtroom, you folks are the last line of defense. The last line of defense between an innocent woman and a system that has tried to break her, that falsely accused her, that tried mightily to bury the truth. This case was corrupted from the start. It was corrupted by biases and conflicts and personal loyalties that you heard about. And most fatally, it was corrupted by a lead investigator whose misconduct infected every single part of this case from the top to the bottom. In our opening comments to you a few weeks ago, we told you what to watch for. We warned you what to watch for. We begged you what to watch for. Watch for the physical evidence. Pay attention to the medical facts. Pay attention to the science and the physics. But also pay attention to the integrity, the very essence, the integrity of the investigation. But you also saw something during the course of the trial that none of us might have expected, something that should sadden us. something that maybe would anger us. On full display, you saw the lengths to which some police officers will go to protect their own at the expense of the rest of us, at the expense of Karen Reed, an innocent woman. Before we examine the evidence in the case, which we will do, we need to understand the very foundation of the entire system of justice in which we operate. It's the bedrock on which this entire system is built. Reasonable doubt. This isn't just a technicality, and it's not a slogan. It's a constitutional shield that protects the innocent and prevents the government from punishing without proof. The Commonwealth has the high burden to prove every single element of every single charge beyond a reasonable doubt and to a moral certainty. As I said, those powerful words are not just some legal jargon. They're your mandate, they're your obligation, they're your community's protection against injustice. In our system of justice, Karen Reed sits here today, presumed innocent, cloaked in the presumption of innocence. That presumption is not fragile. It doesn't just disappear because there's a charge or a badge or a theory. That presumption stands firm unless and until the Commonwealth clears that high bar, the highest bar the law provides, proof beyond a reasonable doubt and to a moral certainty. That means at the end of this case, at the end of the trial, you think about one or more of the charges, you think, you know what, maybe that's true. It might be true. Then you vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you thinks it's likely true or even very likely to be true, your vote is not guilty. It's because none of those standards, maybe, might be, possibly, probably, likely, very likely, none of those meets the extraordinary burden of beyond a reasonable doubt and to a moral certainty. A moral certainty means a level of confidence so strong, so incredibly unshakable that you could go home, you would go home, look your loved ones in the eye and say, I am certain. Not probably, not likely. I'm morally certain, and my certainty remains unshakable. The law defines moral certainty as the highest level of certainty known in all human affairs. Think about that. You must be that certain about the entirety, not part of, the entirety of the Commonwealth's case.
All right, I'm going to stop there. Comments, Nan, I know you're chomping at the bit.
Yeah. So the way that AJ argues this, well, obviously, I'm putting aside the fact that a lot of Free Karen Reed commenters and supporters went out of trial 1.0 right after closings and said, I wish he hammered home reasonable doubt more, or I wish he didn't rely so much on third-party culprit. So in this closing, we see a shift. We see that they were listening. And if they weren't listening, they reached their own independent conclusion that, yeah, we have to focus more on reasonable doubt to a moral certainty and make sure that this jury understands the different strata of that. Like, if you're not sure, even if you think it's likely, it's still not guilty. So he just spoon-fed it to them. The other thing that I thought was interesting and very effective in this, maybe not even this clip, but in this closing, is the fact that Alan refers to science as the silent witness. It's the science, it's the medical substantiation, it's the expert testimony, it's even the expert testimony from the Commonwealth's witnesses, the concessions that were made by Whiffen and Hyde and Welcher and Burgess. Those are things, and the fact that there was plenty of unrefuted testimony that the defense brought forward that the Commonwealth never did. So on all of these fronts, Alan hit, in my opinion, all of the boxes. He touched every single one. I know, Todd, you were saying before there was definitely meat left on the bones. I think overall, speaking as an attorney who gives closing arguments, there's always going to be meat. There's always going to be meat on the bones. I've never walked out of a closing where I'm like, yeah, I nailed that. I always feel like, ooh, maybe I should have said this or that. And it's not till I poll the jury afterwards beyond just, what was your vote? Do you hold your vote? But when we have a chance to question them about what worked, what didn't work, it's always such an interesting social experiment to find that out, what mattered to them. And sometimes I've been told by juries, like, the one thing I didn't mention, they would have wanted to hear. So it's always a continual learning experience for litigators to handle these types of social experiments.
Man, I'm so glad you brought up the secret witness, the science. Being hired as an expert witness myself, you have to stay neutral. Yeah. And as you're gathering all the information, regardless of who is hiring you, you have to stay neutral and objective. And it's the medical records, because I'm a use of force expert. I'm looking for the evidence that is going to be found in those medical documents, in those medical records, because they're unbiased. They don't have feelings. They don't have a perspective. They tell what they tell. And when that information is displayed, based on what we know the case might be and all of the different facts, it's the medical records by themselves that tell their own story, and it either corroborates one side or the other.
Completely agree. And that's a lot of what Dr. Lopesada was saying in her testimony. She's like, and Rentschler, they're like, I don't care because that would not have been relevant to me. I'm just looking at the hard science or the data or the medicine. I don't need to know that, for example, Karen allegedly told someone at the scene, I hit him, or Karen allegedly at the scene pulled a piece of glass from John O'Keefe's nose. Like, that doesn't matter to a scientist. And that's, in my opinion, a major difference between the defense experts and the Commonwealth's experts, because I was so happy that AJ put in his closing today the fact, first off, that he kind of made fun of Welcher for using finger paint and, basically thrusting himself into a taillight and showed it in slow motion. Whoever told AJ or the defense team to slow down a little clip of Welcher literally intentionally moving himself as a surrogate into that taillight. I mean, he shouldn't have been the surrogate in that experiment, but that's creating your own data. That's confirmation bias. So allowing himself, meaning AJ, an opportunity to just emphasize these key little points, that science is the silent witness, that medicine mattered, that it wasn't about having to explain anything. These are things that are immovable. They're constant. They don't change. They don't fluctuate. I'm hoping the jury picked up what he was putting down.
Yeah. And I also like that he made the point when Mr. Brennan got up here and talked to you for the first time in his opening statement, he said that he was going to use science and data to prove to you that Karen Read did this. And obviously they haven't done that. They manipulated the times. They manipulated the data. They use confirmation bias in their reconstructions. Their reconstruction was first grade at best, going back, or kindergarten. AJ used kindergarten and talked about finger paint. I thought that was brilliant because, I love the fact that, just comparing the two, we have two, very astute scientists that work and do research for the military and the NHL, a professional hockey league, designs equipment for them and things for the military. And, my simple thing in all of this is, if I give you two demonstrations and I show you Welcher and I show you ARCA, what are you going to believe? These guys that have brilliant testing and capable video and numbers and data, or the guy that spread blue paint and dressed up like John O'Keefe trying to jump into a taillight and say, yeah, this is how it happened. I mean, I don't know. I'm probably going to believe those guys over there.
I totally agree. And that's why, like, when AJ's saying not on our watch, like, it's your time.
Yeah.
He didn't say send a message. He's really not ethically allowed to say send a message with your verdict. But not on our watch is a way of saying that. And there should be more. The Commonwealth should be presenting an immovable theory. It should never be this moving target. And I loved that AJ mentioned during the opening that the Commonwealth presented a timeline and then changed it in the middle of trial. I actually am shocked that Bev let him do that and that there wasn't an objection. Maybe that was hashed out beforehand. I don't know. It's unusual to get an objection during closing arguments. But these are little nuances that it's the last thing. That's like Adam Tieper was saying on your program on Monday. Juries tend to remember the first things they were told and the last thing. So even though the Commonwealth got to go last today, AJ's closing argument is the last opportunity that this jury was presented with to really hear a cohesive way to tie it all up with a neat and tidy bow. And I think it was perfect.
Yeah. Let's read. I want to just read a couple of chats, and then we'll go to the last 5 minutes of AJ's closing. So we'll listen to that. We'll talk about it, and then I'm going to go to Hank Brennan. We can talk about that and kind of do it in this style. Amy, thank you so much for the 11-month membership. Said, do you think charge 2 will confuse the jury? It is confusing.
There's a lot there, in that verdict slip. There's a lot of information there, but what I do like on all 3 slips, the first choice and first option is not guilty.
Mm-hmm.
I concur with Todd on that. The first choice is not guilty, and it's on all the slips. I'm going to give a little bit of a controversial opinion here. Keep in mind, I haven't studied it all because I was streaming today. Not on my own channel. I don't have a channel, so don't follow me.
You're on Seeking Justice.
I was on Seeking Justice, okay, guys? But the point is, my controversial opinion is I don't hate these slips. I don't think they're that bad. And even though charge 2 is a little bit mucky, it's just a lot there. There's not a lot of clear ways to make that simpler. What the problem doesn't necessarily stem from the jury slips. The problem stems from the fact that the Commonwealth allows your Commonwealth, or those in Massachusetts, your Commonwealth allows prosecutors to throw up all of these charges against someone. So it's like, it could be second-degree murder. It could be manslaughter. It could be OUI. Like, we'll just hope to get one of them. I mean, she was classically overcharged from the get-go. She wasn't overcharged initially. If you recall, she was upcharged. She was upcharged because she exhibited defiance. She said, I'm not going to roll over on this. I'm not going to plea. I know something foul is afoot here. So what do? They upcharged her. And because there is the second-degree murder, because there is all of the manslaughter nuances and lesser includeds within it, any jury verdict slip is going to look a little fakakta, as they say from my planet. So I don't hate it that much. Let's hope they read it and they don't get bullied by some alpha in the room who thinks they're a rocket scientist, because I'm an ESQ and I look at it and say, okay, this is my understanding of it. So if a layperson is in that room and thinks that they understand that slip fully, I'm hoping the jury understands they're all independent thinkers and no one in that room, including the foreperson, has a stronger voice or a stronger vote. So here's hoping to that.
Great points, Nan. Sophie, thank you for being a 9-month member. She says, free Karen Reed. Love you guys. Love you being here. And thank you for supporting the channel and being a member and a moderator. So I appreciate that. Amy says, let's see. He threw shade at all the witnesses, including Barrows. I thought him throwing shade at Barrows was the worst of all. Yeah, it was kind of like weaponizing the police officer that did the right thing in this case. And all the other police officers were involved in this, they were okay. And Brennan, and we're going to probably see it though, it was a very poor excuse to try to dismiss Proctor. Sure, he said those things, but it doesn't change the investigation. Yeah, it does, because
It
we
does.
go back to confirmation bias. In 14 hours, what was it? They were going to pin it on the girl. She's fucked. And I love that AJ said that in the closing. He got that in the end and said she is fucked. And that was the way that they were going to do this.
And you run out of fingers and toes counting all the ways that Proctor did have bias.
Yeah.
I loved that he read the relevant texts. I love also the fact that AJ pointed to a specific exhibit number. He was like, you don't have to take my word for it. Go look at exhibit 209.
Yeah.
Like that exhibits confidence and transparency. And on that point, just one last thing.
Sure thing.
Is when he showed the video vignettes, okay, which I thought were very creatively and selectively chosen. Like, here's the waterfall video, and here's this, here's that, here's the taillight. If the diffusers were broken, that wouldn't be lit up. So these vignettes or pictures were so creatively and geniusly selected.
And I want to add something to this.
Yeah.
I want to add something to this because Todd and I talked about this in the green room, and I have it in my notes. You probably saw it. I think Jackson, again, I'll use Todd's saying here, meat on the bone. I think when he talked about that diffuser and said, look, they weren't even smashed, but in our demonstration, they were smashed all the way through. And he had I don't think he put a photo up, or he might have, because I was listening, not really watching.
Right.
But I think he had an opportunity where he said, and let's talk about this too. And put the taillight photo up there from the Sally port and say, why is it that we know about this taillight? This is the taillight that they're saying came out of Karen Reed's vehicle. And we know that it was snowing and there was a blizzard and there was debris and dirt and sand all over the road. Well, why is that pristine? Why is that pristine? Well, we don't clean evidence. You don't clean evidence. So why is that pristine? And I think that would have been another point that he could have touched on with all the all the malfeasance that happened in this case.
He did say at some point that there was no biological material on any of the shards of the taillight, but you're right. That could have been a missed opportunity. But when AJ was pointing to, for example, the waterfall video, and in line with what I was mentioning about transparency, I found AJ's just description, his narration of what this jury is about to see was extremely matter of fact, without advocacy, without pontification. It was, you're going to see Higgins did this and Albert grabbed his arm and he looked over here and he motioned. It was very plain. And that allowed someone like me, who is biased, to say, okay, he's going to describe it like word for word, almost like ChatGPT would describe it. And then the viewer, meaning the jury, they can draw their own conclusions based upon it. So I thought that was a very good, useful opportunity for the defense to allow the jurors to read with their own eyes, to see it and to not look the other way and be reasonable. And I think they're going to do that. That lends credibility to what the defense is putting down. He's not trying to tell them something. He's shepherding them to their own conclusion.
Yeah.
In the both the opening and the closing, AJ brought facts. Brennan brought a version of the facts.
Yeah.
And I just hope that the jury sees through that play. And, Nan, you touched on something earlier about, the prosecution's witnesses with Welcher really trying to put or make a square peg fit a round hole. You can't change the narrative. Yeah. You can try, but eventually there's going to be holes in your story. So again, all I heard a lot from Brennan was a version of what the truth was.
I love that, Todd. Let's just take a quick break here for a second. If you all are just coming into the chat room and you're not subscribed to my channel here, LTL Media, just hit that subscribe button down below and turn on that bell notification. So every time I go live, You'll be able to come in and watch. And then the most important thing that is free to do here today, smash that like button. We want to try to at least get to 1,000 likes to tell YouTube that, hey, there's a great conversation going on here and people should come over and watch that. So it's free to do that as well. Let's try to buzz through some of these. And I do want to get to AJ the last 5 minutes and we'll talk about Brennan. Let's see. Time to stand, $5. Thank you so much. This question: if the jury finds her innocent, can the judge set aside the verdict and find her guilty? Nan, if you want to answer that one really quick. Yeah.
No.
Yeah. That's it. That's the people have spoken in that. Hang on one second. This just wants to always slow down. StreamYard, you got to fix your platform.
It's working. What's your? I see another chat up there. Why did the defense want the separate OUI charge? I don't know. I'm guessing that they wanted to separate it. You know, lawyers have to play worst case scenario. Like I said before, if the Commonwealth is going to take this, throw everything at the wall and see what sticks approach, I'm guessing that the defense probably said, well, give them the separate OUI charge. And if they're going to hang a verdict on any one of them, let it be that, because the OUI charge would be the least penalty for her. In fact, one might argue that she's already served the penalty because the time would have been served already. She hasn't been driving, but I don't fully know, AKA the cat lady. And it's primarily because I wasn't available today, but I'm happy to message you later, not tonight, but later this weekend with better thoughts for you on that.
Sure. Harsh Marsh, $5 Canadian. Welcome in my Canadian friends. Thanks for being here. So anyone think that AJ was a bit emotional on the last sentence? My heart breaks for her entire team and what all of them have been through. We're going to play that last 5 minutes, so we'll comment on that in a second. Lori, thanks for a 9-month membership. Appreciate that. There's also the new charge, driving while drunk. Yeah, I saw that as well. Nurse Kimberly from the Sunflower State 20 says, I missed it, but when they did the numbers of each juror, I can't see this.
I'll read it.
Go
Would you like me to, my friend?
Yeah, I
missed it. But when they did the numbers, which jurors would deliberate, did they show the numbers they pick?
No.
Also, did the juror who took the 4 to 5 notebooks of notes was picked to deliberate? So no, they didn't show the numbers. That I know. And the one who did the 4 to 5 notebooks of notes, he was chosen to be an alternate.
Yeah, of course. Member, let's see, it's Pierre. Thank you so much. Member for 15 months says, great close by AJ. There is a step in the garage. Yeah, the ledge. He talked about the ledge, and that was pretty good. All right, let's get back up to video here. We'll play through the last 5 minutes of Alan Jackson closing it out.
Asked Dr. Wolf about it multiple times. Specifically, while it was in that plexiglass, asked Dr. Wolf about the multiple holes in the back of the sweatshirt. He interrupted Dr. Wolf, and Dr. Wolf started to look at the sweatshirt and say, and he said, how about here? Here's a hole, here's a hole, here's a hole, here's a hole, dramatically tapping on that plexiglass. It was clear what the suggestion was, that the holes in the back of John's sweatshirt were from January 29th. That's the impression that was expected to be left with you. That's the impression that he wanted to leave with you. And that's false. The truth is, the Commonwealth created those holes. They aren't holes from road rash. They weren't made on January 29th. Those are cuttings from the Commonwealth's own crime lab, folks.
Wow.
That's what those holes are.
Big.
And even with 3 prosecutors, all 3 of them, sitting right there in the room at the time, it had to be the defense to correct that record, to bring out the truth. If we hadn't done that, what impression would you folks have been left with?
Wow.
That's more than negligence. That's dangerous. It's dangerous. I'm going to guess that Mr. Brennan's not going to say much about this, about the fraud that was attempted on you. And if he doesn't, that speaks louder than any concocted excuse that the Commonwealth might come up with. It's shameful. It's shameful. We are after the truth in this courtroom. You're entitled to it. Demand it. Why would the Commonwealth stoop to a stunt like that? It's desperation. They know what you now know, what their experts know. There was no collision. So now we've reached the final moments of the trial, and you've seen the facts and you've seen the evidence, and we've just talked about dozens and dozens and dozens of facts that are reasonable doubt. Each one of them are reasonable doubts. These facts, these note cards that you're looking at, piled high, one on top of another, literally stacks and stacks of them covering the table. As you mentally sift through those cards, realize that every one of them is a massive hole in the Commonwealth's case. Every single one of the note cards represents a hole in the Commonwealth's case. If you're holding mentally even one of those cards, you're holding reasonable doubt, folks. You're holding a not guilty verdict. Reasonable doubt is not a sliding scale. It's a wall. If the Commonwealth cannot get over every one of these dozens of walls, you have to acquit Karen Read. The truth is, Karen Read is not guilty. Not because of technicalities, but because the facts, the law, the science, the physics, the data, they all say so. They demand it. The Commonwealth does not have a theory about how John was hit by the car. They haven't even shown you that it's possible that he was hit by a car. And the reason they haven't is because it's not possible that he was hit by a car. There was no collision. Your job is not to do their job, their burden entirely. It's theirs. They have to prove this case and their theory beyond all reasonable doubt and to a moral certainty. And not only do they not have a theory, they can't prove one that doesn't exist. All you need to know is that the Commonwealth failed. They failed to provide you with a truthful representation. They failed to prove the essence of their case, that John was even hit by a car to begin with. They failed to prove any intent on the part of Karen Read because she has none. They failed to investigate the actual suspects in this case. They failed to present the lead investigator to you. They failed to justify the perjured testimony that you heard discussed in this case. They failed to hold accountable an officer who came in here and lied to you and claimed false memories so she could do the right thing to cover for a fellow cop or cops. They failed to maintain a fair and unbiased and honest investigation. They failed to present you with the truth. And this is what you get. An investigation that's riddled with errors and omissions and a rush to judgment and conflicted and corrupted from the start. Every part of it. That is the literal definition of reasonable doubt. How can they ask you to be morally certain based on this evidence? It's a tragedy. When the government fails so completely, so catastrophically, when there are dozens and dozens of points of reasonable doubt on the table, your duty, your oath is clear. Your sworn obligation under the law is to acquit Karen Read, not just because you can, because you must. Justice demands it. Do not let the Commonwealth get away with this. Don't let them get away with this. Do not endorse and sanction an investigation that is broken and corrupted top to bottom. But just as importantly, do not let Michael Proctor get away with it. And make no mistake about it, folks. If you convict Karen Read of anything, if you convict her of anything, science, the physics, the data, they lose. But tragically, Michael Proctor wins. Remember his texts. Something stinks. Yeah. Serious charges will be brought on the girl. She's fucked. Could you ever say to yourself, this is justice? The fact is there was no collision. A car did not kill John O'Keefe. So I ask you, let your voice be heard, not in whispers, but in truth. Let the community feel through your verdict that justice cannot be bent and that it will not be buried. Find Karen Reed, not guilty, not guilty, not guilty. Thank you.
That's your masterclass, Brian.
Woo.
That's your masterclass.
Woo.
You're muted, Nan.
Sorry, I was sobbing listening to that.
I got a question.
Don't make me cry. Okay.
Is it tough to separate the emotion from your clients? I mean, do you get emotionally involved in all of your clients, or is this a different case?
Every lawyer gets emotionally invested in their clients. To what degree varies. Me, I'm a very passionate person, so I tend to get extremely connected to my clients and their causes. What I observed from AJ today and from the attorneys for Karen sitting at the table, I encourage anyone to watch again, and any shot they had of Yannetti or Alessi, like, take a look. They're invested too. AJ looked, I mean, sad. He looked impassioned. He looked withered. And I don't mean to insult him, but think about all the days where he's kicking ass and taking names. He looked tired and emotionally invested today. Like, he felt every syllable of what he said. He raised his voice. He's yelling the word truth. I mean, this was by no means artificial. He believed what he said. And I'm sure that closing argument, you know, he's been on trial for 8 weeks, 9 weeks now. Like, I'm sure he didn't, and it's not just him. I'm sure the team didn't just work on that the whole time. You know, you don't know how witnesses are going to twist and turn or how evidence is going to develop itself. I'm sure that closing argument came together in the final hours, and he didn't memorize it. He felt every word of it. Juxtapose that against Brennan. Brennan didn't believe a single word he said.
We're going to get to that.
Yeah.
We're going to get to him.
It's hard not to be emotional to listen to what was argued there. It was great. What do you think, Todd? I didn't see any tears from you, Todd.
No, it was just he broke it down so passionately, so articulately, and personally, right? This is personal to him. There are a lot of games played in this so-called court of law, and they constantly the whole proceedings were like they were jousting. It's one thing to argue your points, but this was catching Brennan in shenanigans over and over and over again. Like, how do you represent your client well and also have to be able to shield against shenanigans in angles because he doesn't have a case. So what does he do? He tries to make witnesses feel bad. He tries to present information inaccurately. In knowing that Bev Canoni is on his side, he's gonna exploit that all day, every day.
I think that's a great observation. That's it in a nutshell.
I think what we saw at the end there was just 3 years of hard work. And I think 3 years of what we've all felt, the people that have been extremely connected to this case. And I was honest with Nan. I'll be honest with everybody here. Nan and I were texting really early this morning, and I told her I've already melted down.
Yeah.
I already had a meltdown. I mean, hey, I'm emotional. I'm a guy. I'm secure in my emotions. I let it out. You know, I've been here for 2 years on this channel fighting for Karen in the capacity that I can fight in just bringing people around and educating them with the live shows that I've done and have all these amazing people on my panel like tonight and all the friends that I've made through all of this and getting to know the Reeds and being outside that courthouse and being emotionally invested in it. It's hard and it's going to be hard. And it was hard today. But I think that what we saw was 3 years of hard work and fighting. And believe me, they have had the boot on their neck through the entire 3 years. This judge has given nothing to them. Nothing. They've had to fight all the way through this. And I think it was powerful. And I think he probably felt that this was the best closing argument he's ever given. And that's what we saw there.
Yeah. And Brian, what I didn't text back to you this morning is I was feeling the same way.
Yeah.
But I put it aside to help you push you through, because what you're feeling, and you're not alone, are very human emotions. And I saw it in people's tweets today. I saw it in the faces and some of the commentary from boots on the ground that I was able to watch this morning that we're streaming. Like, everyone has what's called anticipatory stress. It's this feeling of what's going to happen. Is all of this time investment and this passion that we have for seeing justice prevail. And it's, as Aiden says, this is good against evil. I mean, it really is. And, there's so much investment personally, and no one knew how good AJ and the defense team were going to stick the landing, right? It could have fallen flat. It was a great closing in 1.0, but people critiqued it and felt like, I wish we heard more about reasonable doubt. I think that was shored up today. I think that overall, all of this anticipatory stress, it's not going to subside. It's not even going to subside the minute she's acquitted. And I still think she's going to be acquitted. I feel with certainty that she will. But the minute she is, everyone's they're just not going to unclench right away. It's going to take time. And it's good to have a groundswell of support. So you can always reach out to me.
Yeah. What was I going to say? I saw a very emotional tweet from Aiden today. Aiden was very emotional in some of his tweets, and there's people, like, I don't want to stack on anybody's emotions. People show emotion in different ways. People get connected in different ways. I'm very emotional. I'm Pisces. So I'm a typical Pisces. I get involved when I'm passionate and involved in everything. I pour all my emotions out. I'm not afraid to do that. I'm not afraid to show. I'll cry. I don't care. But
me too.
Some people hold it back. Some people won't be as connected through their channels, but maybe offline they're a little bit different. Whatever it may be. But I saw, like, Aiden was tweeting, and I don't have it verbatim remembered, but it was like, pray for Karen Reed, pray for the lawyers. It was something in that sense. And it was just very emotional to see him tweeting like that. And I thought it was great. I put a statement out to the Reeds. Today, my heart is full of love for you, your family, attorneys, and for the supporters of Karen. May God shine his guiding light over Norfolk County and lead these jurors to a not guilty verdict. And once and for all, Karen Reed will be free. And that's what I put out there today.
Well said.
Pretty amazing. It is. And it's such an emotional time for the family as well. Like, they don't know what this could, Karen could have been convicted today and never not go home. Who knows what it was like for her to sleep last night. I mean, I've heard stories from Aiden, that he talks about on his shows where he'll say, like, I don't want to go back to jail. I don't want to, like, it's not
fun.
It's nowhere I ever want to be.
No.
So all of this emotion, I will say, though, with all the emotion that's wrapped up in this, it did provide a lot of relief to me to hear that closing and to hear the defense stick the landing juxtaposed against Brennan's utter failure and clear demonstration to me that he doesn't know shit about this case and he doesn't believe in it.
All right.
Let me circle this back to some Nan Gallagher attitude.
Well, that being said, let's critique Hank Brennan. I'll play the first first 5 and the last 5, and we'll get lost here.
Let's have some fun.
And we'll try to make some sense of all this, what's going to go on. All right, everybody get their crazy hat on because it's going to get crazy. Here we go.
John O'Keefe was 46 years old. 46 years old. He spent his life helping people. He's described as a good man, kind, generous, thoughtful. He was a Boston police officer. He worked to help the community. Everything you've heard about this man, he was a good man. He helped people. When his niece and nephew had nobody, he took them in. He took them in. John O'Keefe seemed to be the type of person who would help anybody at any time. And on January 29th, 2022, John O'Keefe needed some help. He needed help from somebody else.
And that help should have been from Brian Albert. If it was
took
the way
the words right out of my mouth.
And I'm going to pause here and talk about it because I made a comment today. I put a tweet out, Todd, and I said that right after he said this. And I said, if this was the way that this happened, the Commonwealth said, and he's going to burn himself here because he's going to go and lights are flashing and there's trucks coming and there's commotion and there's people. Well, then why didn't Brian Albert come out of his house and help him out? Go ahead, Todd.
Yeah, nope, you took the words right out of my mouth. The one person in the best position, he was right there on the property.
Yeah.
40 feet away from the curb.
Nan, anything you want to add before we go back to the video?
I just think it's also, before I forget, one of the things that he mentioned twice during his closing was that Karen has to have the last word.
Yeah.
That it's somehow his theory, and we didn't hear the testimony of John O'Keefe's niece, but apparently there must have been testimony elicited from her that when they would argue, Karen would want the last word. And it was mentioned twice by Brennan in this closing that, well, she made this choice. They were fighting. They weren't getting along. She decided to put her car in reverse. And I think that's a ridiculous theory. This is so generic. Like you're going to convict someone because you think Karen, you're going to charge someone because you think Karen needed to have the last word and throws her car in reverse. And notice, unless I missed it, he didn't spend any time, if much at all, on the key cycles. And, the data clearly shows that this is how far she backed up at around this time. And it had to have been outside of 34 Fairview. It couldn't have been this. It couldn't have been that. He didn't even exclude alternate plausible theories. I know that wasn't in the clip you showed, Brian, but I felt the need to mention that to you.
No, we're going to go back. We'll play another. We'll play 5 minutes and then go to the last 5. Here we go.
You see, John O'Keefe had just been hit by Karen Reed in front of 34 Fairview Road, and he lay on the ground dying, and he needed help. Someone to reach out a hand.
Brian Albert.
Someone to knock on a door.
Brian Albert.
Someone to make a phone call to 911, even anonymously. Not take responsibility, just to help. And there was only one person in this entire planet who could help him that morning, to give him a chance.
Brian Albert.
Maybe it was a 33% chance if he met the Isaac Wolf of the world. But to give him a chance. And that one person who could help him that morning was this defendant right here, Karen Reed. And she made a decision. In her Lexus with the shattered taillight, debris field all over the front yard, and John O'Keefe lying helpless like a child on the front yard. She made a choice.
There you go, Nan. She made a choice.
She didn't call 911. She didn't run to his aid. She didn't knock on a door. She made a decision about herself. in her Lexus. She drove away. She was drunk. She hit him, and she left him to die. She was drunk. She hit him, and she left him to die. Before I go through and detail the evidence, let's talk a little bit about the evidence as a whole. She was drunk. She was drinking that night. She was drinking McCarthy's with John. She was drinking at the waterfall. Her blood was taken. The samples, the retrograde analysis, almost 2 to 3 times the legal limit. She was drunk. She hit him. The timeline in this case is beyond dispute. You can accuse, assault, characterize, malign, twist. The timeline doesn't change. It is data. Data is data. The black box, the forensics from the SD card, we know exactly.
So we're getting in, but I just want to pause this right here and look at the Commonwealth table versus when you saw the defense table. When AJ was speaking, everybody at that table watched Alan Jackson for an hour and 15 minutes. Now you're looking at the Commonwealth. They're not even looking at Brennan. Lally is playing with paper clips again. There's no one watching him. You know, this is the defeated team that doesn't believe in anything that Hank Brennan brought forth to the public. I mean, it's crazy to see this. Let's play through about a minute and a half, and then we'll opine on this opening.
Step by step where they were. We know in that window, she hits him because he never moves again. His healthcare data. The temperature on the battery of the cell phone.
Yeah.
The physical evidence, the debris field, the DNA, the hair. And then she left him to die. He had a basal skull fracture, counter coup. You heard all about it when the back of your head hits the ground and the brain comes forward. Dr. Wolf told us the reason why they have level 1 trauma centers around the country is because people can survive this injury if they get help.
Commonwealth table. Look,
that's why they have this care. That's why they have these hospitals. But you got to get help. You got to get help. And if you don't, you develop symptoms, ecchymosis, raccoon eyes, your brain swells, and you die.
All right, we'll stop there.
I have thoughts.
Go ahead, Nan.
Sorry, Todd. I gotta jump to it on this.
Just shaking his head. Nah.
He looks passionate though. But so here's my thoughts. First, this is all conclusory statements. He's got an hour and 15 minutes to get into the weeds a little bit, just a little bit. He doesn't do that. He's speaking in absolutes. It's the data, the science. He doesn't give clear explanations of what the data and the science show because, truth be told, the science and the data prove the defense, prove the fact that there was no collision and that Karen didn't hit him with the car, etc. The second point I would have, and I'm so happy I was able to take notes tonight, is that I noticed this pre-trial. In the months leading up to trial, Hank kept making arguments on motions about how John could have been saved. That had someone intervened, had measures been taken, had the authorities been called, he could have been saved. I'm going to tell your audience something as a healthcare lawyer who deals with doctors who treat and fail to treat injuries in the field of medicine. It doesn't matter if John could have been saved for criminal liability. In this case, I'm hearing background noise. I'm not sure it's coming from my computer, but in this case, it doesn't matter if Karen made a choice and backed the car into John O'Keefe and drove away, or if she backed the car into him and then ran to his side and said, "Oh, I'm sorry, I hit you, and now you're going to be dead and dying." It's irrelevant. So I never have understood why he goes that route. It doesn't matter that there's a level 1 trauma center hopefully nearby. It doesn't matter any of that. That to me is a Distractor.
Yeah.
That's what Ronnie, if he were on the jury, thank God he's not. If he were sitting in the jury deliberation room, that's something Ronnie would point to and should point to as a distractor. It doesn't matter that John could have been saved. It's the act of allegedly hitting him. That's the criminal conduct. And it's whatever her mens rea or state of mind was at the time she did it determines what level of culpability she has. Go ahead, Todd. I had to get off my soapbox on that one.
No, it's all great stuff, Nan. You know, I want to go back to the reference I made earlier about Brennan telling a version of the truth. And let's go back to Dr. La Posada, her testimony about the injury to the back of the head. We can all agree that John must have fallen backwards. And we can say it came from a punch, a push. However that causation happened, it caused him to fall back and hit his head. She was very articulate and explicit about the nature of the injury and the splitting of the skull. You don't get that on a flat surface.
Yes.
I've looked at a lot of medical. There's some type of a ledge or edge that created a laceration along with that head trauma. So, you know, again, he just throws it out there like no one's paying attention. Brennan does.
Yeah.
And he's just the way he goes about things. He doesn't bring factual information.
Yeah. And I agree with that. And to that point, Brennan in the trial wanted the jury to like assume, okay, well, if he fell back, then he must have hit his head on something on the lawn or something in the dirt, you know. And that's not
hard ground.
Yeah. Like that's just not that's not what a prosecutor is supposed to do. And that does not amount to beyond a reasonable doubt. You have to, as the prosecution, tell them exactly how the theory unfolded. Do you have to tell them every single nuance? No. But what he should have done was say, you know, he clearly did fall backwards, hit his head. The evidence is going to show that the split was such that he must have hit something of a hard nature or with a lip or a ledge to it. While the terrain has changed since then, 3.5 years ago, it is plausible and very likely that there was a rock or debris or sticks or stones or curbs or whatever he wants to say. That's how you lay it out while not knowing exactly what he struck. But Hank doesn't do that in this case.
How about placing the rock back out in front of, this is going back to the beginning of the trial. How about putting that rock out there that said Alberts on it to suggest to the jury that that's probably how John hit his head. He fell back on that rock. That is sick and twisted.
Even with that, it was a flat rock.
Yeah.
That's a fair point.
Sick, though, Todd, that they would do that.
Well, we don't know. Brian, do we know it was them, the Commonwealth? I mean, we don't know.
I mean, listen, it wasn't there when I was just there like 2 weeks before. I was down there with Lauren. Again, I don't like to go down there and call it like the death tour. I don't want to do that. But she hadn't been down there. And we went out to eat in that area. And I said, well, why don't we take a ride by ferry? She hasn't seen it. So I wanted her to see how close the house was to the road and how much smaller that yard looks. And we just got out and walked it. I didn't see that rock there. I don't think the new owners would put a rock out there that said Alberts. They actually had a memorial to John on the front lawn right near the flagpole. They had this little memorial card or emblem that we saw. And we was like, oh, wow, they actually have a tribute to John there. But that rock was not there.
Now that we know Dr. La Posada's opinions that there was a ledge or a ridged surface that he would have struck that caused the split on the skull, or the skin, the soft tissue, and then the fracture. I now believe that the Commonwealth, in some way, shape, or form, or those with whom it chooses to associate or get its inside information and choose your own, fill in your own blank on that, had something to do with the placement of that rock.
Yeah.
That because the science is irrefutable. And I think Hank knows that. So that's just my personal opinion, but I don't believe in coincidences.
I can pull this up. Where was that? Said John DePietro probably did it. Or Jennifer Coffindaffer. Remember when she got caught on the new homeowner's camera, like taking video up in front of, like, what are you doing? Like,
Yep.
what are you doing?
She's a creeper. She's a creeper.
You know what the funny thing is, and you're all gonna laugh. She was my first
I know.
big guest on this channel, Todd. I had her come over and talk Idaho 4 with me. She was
I
like,
remember
grown.
Oh, don't worry, Brian. There'll be plenty of opportunities to interview her on the Idaho 4 once Karen's acquitted.
I had her on my channel. That was the first guest I had, like big guest I had on my channel. But oh God, times have changed. All right, let's play a little bit here at the end. I might have to refresh this. Hang on, I'm getting the swirly bird here. Give me a second. Let me just pop that up.
Nothing about Hank Brennan is refreshing.
All right, let's play 5 minutes of this one here. Here we go.
Find a dog bite. So enter Dr. Russell. Dr. Russell, according to her, nice woman, nice doctor, very accomplished. I respect that. She's the only dog expert in the world. The thing is, we know no idea what that expertise means. She volunteers for the job. She wants to be here on her profile, but she can't explain methodology. What are you looking for in a dog bite? She can't tell us. It starts a year ago that it's claws, it's teeth, and then it's claws, then it's teeth, and then it's I don't know. And then when you look at each of the different parts of the abrasions, she says, well, I can't tell if I look at each one of them, but all together it's a dog bite. It's a dog attack. That is the masterful expertise that the defense has bragged about bringing in. Dr. Russell telling you, because she says this is a dog bite. She has never been in a forensic situation where she's looked at a wound and identified it as a dog bite before. This is the first time, the only time she's ever done it. And what she says is these are not punctures. Punctures means it goes into the skin, a wound. There's no punctures. And she's sure because she's an expert, so you should rely on her because she's coming in saying she's an expert and she's being presented. Yet, after saying there's no punctures, Dr. LaPosada comes in and she sees punctures everywhere. It's an animal attack. It's a dog. How is it? No method, no methodology, no history of this, no prior testimony that we know of other than arbitrarily what she says. And she says the exact opposite of Dr. Russell. Why is that? How does that happen? So obviously there is no science to looking at an abrasion and saying where it came from. They give us no detail. They give us nothing that we should rely on. They contradict each other. It's just to get you to look the other way.
There you go, Nan. Look the other
So we
way.
have now the issue of the defense has said over and over again, there's no collision. There's no collision. There's no collision. And they had a number of witnesses come in to try to say that. And they point to Dr. Scorti-Bello, who works at the medical examiner's office. She tells you that she doesn't see injuries consistent with a collision. She's looking at this case for 90 days. 90 days. The evidence in this case did not stop. It continued for 2 years. She knows nothing about the data, nothing about the black box, nothing about the interviews of Miss Reed.
He doesn't have to.
She doesn't know about the DNA. She doesn't know about the
Son.
shards in the arm or in the clothes. Strike that in the clothes. She knows nothing about that.
And it's so funny that I was just thinking, I was going to say, there's a point in this that he strikes something. I want to go back and listen to that again, what he struck. Let's go back and let's try to catch this.
90 days. The evidence in this case did not stop. It continued for 2 years. She knows nothing about the data, nothing about the black box, nothing about the interviews of Miss Reed. She doesn't know about the DNA. She doesn't know about the shards in the arm or in the clothes. Strike that in the clothes.
Shards in the arm. I missed that.
He just impeached his own witness.
Yeah. That's why he struck it. Let's go back here.
This case for 90 days. 90 days. The evidence in this case did not stop. It continued for 2 years. She knows nothing about the data, nothing about the black box, nothing about the interviews of Miss Reed. She doesn't know about the DNA. She doesn't know about the shards in the arm or in the clothes. Strike that in the clothes. She knows nothing about that. So
Wow. He just impeached himself.
How? What am I? I'm a blonde, but he said on the clothes, and then he said strike that in the clothes.
No, he said
On the arm.
he didn't know about the shards in the arm. Strike that in the clothes.
Oh, all right. It's been a long day.
It's okay.
Yeah, I mean, that was a Freudian slip. There's probably some significance to that, but the defense didn't object, which is rare, as I said, to object during your adversary's closing.
Yeah.
But I want to think about that, if there's any more significance to it. I'm trying to remember, though, during this trial, what was the evidence that came in as to the DNA? Anyone? Anything? Like, he mentioned the DNA, but
What was the touch DNA on the back of Karen's SUV?
it was
that they
touch
found inside the Sally port.
on the smooth part of
Right.
the tail light. Okay.
Right.
All right. Were you done with that clip, Brian?
I'm gonna play the last 2 minutes. I sped up a little bit. We'll just play like the last 2 minutes and see how he ends, and then we'll opine on this.
Yeah.
All right, here we go. Last 2 minutes here, folks.
Get out of the car, and he had a brief window of life left. But when he got out, and she drove away, she couldn't let it go. She got drunk. She hit him. She left him to die. It's that simple. We don't know exactly how this collision happened, but we have a good idea from the physical evidence, and we know that it happened. Can someone have a collision without lower body injury?
We have no idea how the accident happened, but
But we know. Trust me, bro.
because of the data, but we don't know.
Yeah, like that's what we call an argument ad absurdum.
All right, here we go.
And he had a brief window of life left.
Play it again.
But when he got out, and she drove away, she couldn't let it go. She got drunk. She hit him. She left him to die. It's that simple. We don't know exactly how this collision happened, but we have a good idea from the physical evidence.
Good idea.
And we know that it happened. Can someone have a collision without lower body injuries? Could I have slide 19, please?
Here we go.
You bet they can.
Oh, you're gonna show the swipe.
We don't know if this is the body position. We don't know if this is the exact speed, but what it tells us,
We don't know.
this is viable. Look at the debris field. Look at his turn. Remember his sneaker on that curb that got lodged against the sneaker? Mr. O'Keefe then falls back.
This is. I gotta stop here for a second because I want to go back and just show everybody. Here's the problem, Hank, and this is actually a perfect spot to. You're saying, here's the problem. That tail light does not look like the tail light that you entered in evidence, pal. The lens is still in it. Clearly, the evidence photo that they showed from the Sally port, the tail light does not look like this. So he's damning himself right now. I mean, he's I don't know. I'm lost. He's literally saying we don't know how it happened, but it happened. And someone put in the chat, anything's possible.
He impeached himself.
Right, but even go one step further on that video. He who the hell stands on the road with their hand? I mean, was he hitchhiking? Was John O'Keefe hitchhiking a ride home? Like he's standing on the side of the road with his cocktail glass. Like rewind. I'm sorry, Brian. I don't want to tell you what to do on your channel.
We're gonna do this. It's
but
fine.
Everybody should. And I believe this was an ARCA. Was this an ARCA?
It is. That's what he's trying to do here.
He's a hitchhiking now.
Yeah.
Like who stands like that? Was he?
Okay. But this is what I want to pause it on is that you all know what the tail light looks like. That doesn't even look like the freaking tail light of evidence that they entered, Nan.
Right. And I was saying to someone, I don't know who it was this week on one show, I said, look, you don't know what every experiment that ARCA was doing was testing. Each experiment they conducted was testing different things. And I'm sure Rentschler and or Wolf, more notably Wolf, could explain that better. Like he probably did. He probably looked at that that video and gave testimony that this is what we were testing at this time. It wasn't necessarily this is how the accident took place. But yes, it's not even the same type of taillight.
So here's the evidence photo from the Sally port. The whole red lens is gone. And now he's trying to say, well, here, this is what would happen. And I'll go back to the video. That's
Brian,
not even close to the same, Todd.
Also, those inner marking, those inner light or
The
white
diffusers.
lenses, the diffusers. Yeah. Thank you. Those were completely obliterated along with the rest of the housing. And,
Right.
and none of the testing that ARCA did went that deep as far as the damage to the tail lens. Also,
it was just surface. Yep.
All this shows is that there should have been more damage to John O'Keefe's arm.
Of course. But
Agreed.
We'll play out the last minute and a half here, and then we'll finish up.
Look at his turn. Remember his sneaker on that curb that got lodged against the sneaker? Mr. O'Keefe then falls back, hits his head, counter coup, left to die. Thank you.
That's it.
Wow.
Ladies and gentlemen, there is no doubt what happened that night. There is no doubt who did it. You have a very difficult task ahead of you when you consider the evidence.
Look at his
consider
team.
the
They're not
law.
even looking at him.
Very difficult. There are 3 charges. There is second-degree murder. Ms. Reed, when she chose to drive back at Mr. O'Keefe in that night with a 6,000-pound Lexus, in that anger, 75%, whether she meant to hit him or not, didn't mean to kill him, she hit him. Strengths, it is a plain and strong likelihood of death. You would never get back down your driveway if the kids were at the end of the driveway. You'd say, well, you're going to kill somebody? You would never do it because you would expect, if you drove at them at that speed, that someone would die. That's second-degree murder. OUI manslaughter, she's drunk, she was reckless. She doesn't have to know she hit him. She doesn't even have to know she hit him. But she did. She did. And she left a man who was kind and generous and thoughtful. She left him alone. She left him alone to die.
Ooh,
Could I have slide 22, please?
this is weak.
This is really bad.
This is weak.
He is not an it. John O'Keefe is not a body.
This is weak.
John O'Keefe is not a buffalo on a prairie.
Oh, we're now at the buffalo on the
John
prairie
O'Keefe.
part of the closing.
And he was murdered by Karen Reed.
Really?
By the way, he doesn't even that is a huge pet peeve for me. He said and he was murdered by Karen Reed and walks away and sits down. Thank them. How about you thank them for listening to you?
Todd, you were coming out of your seat there.
Yeah, I'm just going to repeat myself from earlier in that his version of the story is so inadequate and is so incomplete, and I just really hope the jury hears the portion of the truth that he's giving. What a crime! In and of itself, he's a crime.
He burned himself in the last 5 minutes of that closing argument. Well, maybe it could have happened. I mean, we don't know
how it happened.
Yeah, we don't know how it happened, but we might have some data that kind of lines up with it. Oh, and sure, it of course it could happen. Here it is. And then he shows that video, and like Nan was saying, why would anybody stand there and go, hey, all right, car's coming at me, like, hey,
Yeah, stick it out.
Like,
The act of desperation is when he turned on Scotty Bello.
Yeah.
Yes.
That's desperation right there. He impeached his own witness, said that she didn't know anything about anything else, relying on her testimony. He called her to the stand.
Yep.
Oh yeah, and that's actually I was looking at my notes, and Todd had commented on that while that clip was playing. I forget what the statute requires up in Massachusetts, but medical examiners have to issue their findings within X period of time. I
90
don't know.
days.
Is it 90?
It's 90
Okay.
days.
So let's assume it's 90. And yeah, so she issued her opinions within 90 days, and he's saying the evidence was ongoing. Medical examiners can modify their reports at all times. Like they can someone can make an application like, here's new material, new information. Do you want to change your findings? That rarely happens, but it can. But the fact that she didn't apparently consider, because it didn't happen yet, the discovery of the black box or additional data or the confessions, the alleged confessions of Karen, these are things that would not affect a medical examiner's findings. And I thought La Posada explained that beautifully. She's like, I don't care about any of that. I'm looking at the body. The deceased is my patient, so to speak. And the other thing I was going to mention is he did shit all over Marie Russell. Like, she calls herself an expert. She inserted herself into this matter. And, you know, I think that's not going to read well, because by all evidence to the contrary, the woman seemed like a very giving soul. Did she testify previously as an expert on dog bites? No. Did she testify in this matter that she just thought she might be able to help? Yes. She came across as very credible. So I don't think it reads well to a jury if you're going to dump all over her, even with her not in the room, because had she been in the room, she would have gone toe to toe with him. So it's like, it takes a coward to start insulting someone when the person you're insulting isn't in the room. And on that note, I would say I loved what AJ had said when he kind of dumped all over Burgess a bit as to his credibility. He's like, if you don't believe me, just look at his CV. I thought that was
that was great. That was really good. That was really good. Do we have a few minutes? I'll pull the verdict slip up. Do we have a few minutes?
Yeah, but I'm not making any promises, folks, on the quality of your legal analysis this evening. It's been a long one.
Yeah. So we got first page here. Offense 1, murder in the second degree. We have the not guilty right at the top, the guilty below, guilty of offense of charged murder in second degree. This isn't a unanimous decision of all 12 members. And then you have the 4-person and the signature and date. And then this is, let's see, Commonwealth of Massachusetts verdict slip. We have offense number 2, manslaughter while operating a motor vehicle under the influence of liquor. We have not guilty of the offense charge of any lesser included offense. And we have guilty of the offenses charged, manslaughter while operating a motor vehicle under the influence of liquor. Check one or both of the following: manslaughter while operating motor vehicle under the influence of liquor, and or manslaughter while operating a motor vehicle with the blood alcohol level of 0.8% or greater. Oh God, this is a mess. Guilty of lesser included offense, involuntary manslaughter, guilty of, there's so many charges that's in this.
And as you're reading through it, by the way, and Brian, kudos to you for reading that without your glasses on. Wow. You know, while keeping this high level, I will say a few things. I don't see that there was a way for the parties or the court to make this much simpler. And it's because, as I was saying earlier, there's the Commonwealth throwing all of these claims out there, these charges, and to see what sticks. So all of these have, you know, it's kind of, if you believe this, then go to the next step. There's all of these subparts to it. Right. But what I don't know is, and I have to believe they did, I don't know if the defense opposed this, or if this is what we're looking at, and this is the final agreed version by the Commonwealth and the defense jointly. I don't know the answer to that, but I don't think it is confusing. I agree, Gretchen, Leah. It is confusing, but let's keep optimistic, because it says right at the top of that sheet,
not guilty.
Yeah, I
think that's what needs to be focused on here. I don't know. That's a lot. It's very confusing. I don't know. Maybe I'll do an experiment later and throw it in Chat GPT and see what AI brings back to me.
That's interesting. That's actually a good experiment. And also, if I recall, in trial 1.0, the issue on the second charge was that it didn't say not guilty at the
Right.
top. It and then AJ went at her and she was like, he's like, how did the jury know that they can choose not guilty? And she's like, well, then they don't select guilty. It was like, it was a bad assumption that the judge was asking the jurors to make. This is an improvement over that. I will leave it at that. It's an improvement. It's still a messy, confusing form.
Todd, anything you want to add here before we wrap up?
Yeah, just count two looked really sloppy, really muddy, but I do like that they put not guilty as a first option. So if that's where they're at, there's no ambiguity there.
Yeah, I agree. Well, it looks like this is going to go into Monday. Obviously, maybe we get something after the weekend here. Those jurors get home, they can think a little bit and come in and wrap this up on Monday. And, I still feel very confident about this, that it's going to be a not guilty. I can't see from a state's or Commonwealth's standpoint that they proved anything here. I mean, even Hank Brennan at the end that we just saw in his closing argument, he's still confused about the case.
He is.
Maybe, what's that, Todd?
He's doubting himself.
Yeah, I mean, maybe it could have happened. We don't know. We'll just have to see what happens on Monday. So again, everybody, please pray for Karen, her family. If you can, click her defense fund link. They still need funds. I know what it costs to run that team per day. I know the number, and they still need funds to eat and research and get through the rest of this trial. So if you can contribute anything, please do. I did a $9 donation. I was trying to get everybody to at least donate $9 for not guilty, because that's as many letters in not guilty. And if anybody wants to do that, please. And I'll drop the defense fund link in there. Do the $9 or 90 or 900 or 9,000 would be great. And I'll drop the link. And if you want to contribute to Karen Reed's defense fund, we would appreciate it. And I know the family would, and the defense attorneys would as well too. So, all right, well, that's going to be it. We're going to wrap up the show. I'm going to give these wonderful people some time back tonight. I know they've been up and watching the case all day. I've been in and out during work and trying to keep up as much as I can. I know Nan streamed a long time today. Nan, I appreciate you for your time today. You need to go get some rest.
Yes,
please do. And, I appreciate you both being up here. And then we'll be back on Monday. I think the gang's going to come in studio, barring what's going to happen on Monday. We're going to do a live here and talk a little bit about it. It's going to be on Monday night at 7. We'll be in here. I'm not sure if I'm going to do anything as far as programming. No, I'm not sure if I'm going to do anything on Sunday. It is Father's Day. Everybody should go out and enjoy stuff with their family. Maybe I'll take a break and come back on Monday. But thank you, everybody. I appreciate everybody. Appreciate your time. Make sure to like, share, and subscribe. Comment down below. And we'll see you back here on Monday with the Power Trio here. Everybody have a great night. Take care, guys. Bye-bye.